Thank you, Paul, and good afternoon. My name is John Swallow, Chief Deputy Attorney General. Appreciate the opportunity to explain something. This truly is a monumental day for access across federal lands by Utahns, and there are many people to thank for this day, including, I noticed John Harja is here in the back. He told me a minute ago he's been working on this project for 12 years now. This is truly a monumental day. And we're here to announce that Utah has nearly finished filing all of the lawsuits needed to preserve access across 12,000 roads in 22 counties throughout the state of Utah. Again, it has been a monumental project to preserve access across federal lands, and each road was used, each road in our complaints has been used continuously for at least 10 years prior to 1976. So just getting the information together to prove up on these roads has been a monumental task, and we appreciate as a state working with the counties and working with all the people who've helped us to on this project to get to this point today. I want to explain briefly what these actions will do. First of all, the actions will preserve access for families to use the same roads they've been using many times in the past for important purposes, recreational purposes, for hunting and fishing, and picnicking and enjoying the ultimate destinations that these roads get them to. It's also important for access to our natural resources, such as water and minerals, other natural resources such as potash and coal and natural gas and oil. And finally, access for safety purposes. A lot of these roads have been some of these roads have been in dispute, and the ability to actually firm up title and the right to use these roads will allow us to improve these roads in a way that they haven't been improved for a while, so that there is safe travel across these roads. What this action will not do, we will not be paving deer trails or turning dry creek beds into 4-lane highways. The point and purposes of these lawsuits is truly to preserve the right of Utahns to access across public lands, and that is what we're going to be doing, and that is the process we have to go through legally to do that. Historically, RS 2477 was enacted in 1866 to recognize and validate a system of highways and roads in the West over public lands. The law was repealed in 1976, but Congress granted the states and counties the right to continue to access roads that had been historically used for at least 10 years prior to 1976, and that's why October of 1976 is such an important date for us. The process, again, is that we either were able to negotiate with the federal government how to decide which of these roads were validly used under RS 2477 historically, or to go to court and actually litigate the issue. And we've unfortunately been forced into this posture of litigation to resolve all of these issues on these roads. Now let me just give you a couple of examples. We have, and I don't know if we have the Ivapaw Road here. Which road is this?
John, let me move you up just a little bit, just to you're kind of in and out of the light there.
Okay. One of the roads that's in dispute that we have not been able to resolve with the federal authorities is the Ivapaw Road, which is actually a paved highway. Again, we're trying to say that we've worked hard to get a concession from the federal government on some of these roads, and we just haven't been able to get it resolved, and so we are forced to take our legal remedy and go to court on roads. Another road is the Last Chance Cutoff Road, and having a concession from the federal government, this is actually a road. It's actually the road to the Last Chance Ranch, and has been used for many, many years on that. But that's kind of the difficulty we've had in trying to resolve these issues on these roads outside of the court process. Another road is another D road, which is TC 2390. I don't know if we can pull that up. Again, the dispute about whether this is a road and whether it has been accessed as a road for 10 years historically prior to 1976. And one of the reasons we've had to move quickly on these roads, if you can say we're moving quickly, is because of the statute saying they have to be used historically for 10 years prior to 1976. A lot of our witnesses who can testify about how these roads were used historically, they're getting older, they're moving away, or they're actually dying off on us. And so one of the things we have to do for each and every road that we're suing on is provide evidence in court as to its historical use for 10 years prior to 1976. Now, in conclusion of my remarks, let me just say that, as I've said before, this is a necessary process the state has had to go through, and working with the counties on identifying these roads to preserve the right of Utahns to access these roads over public lands. And one of the concerns we have, as surprising as it may sound, even though we have 12,000 roads we're filing on over the next week, is, are we doing enough? Are we leaving some of the roads out that we need to actually be filing on? Because if we don't file on these roads and go through this process of quieting title in the counties and the state of Utah, then the federal authorities will have the right and an opportunity to close these roads and deny Utahns the right to access these roads in the future. And we can't stand by as a state and lose the right to access these historical roads that we have under federal law. So those are my comments. Kathleen, I'll turn some time over to you, and then we'll be available for questions when we're done.